proposed that the defendant responded to the previous statement of facts instead of the extant amended statement of facts. Consequently, it is imperative to amend the statement of defense to enable the defendant to properly address the averments contained in the amended statement of facts. In opposition, the claimant filed a counter affidavit contending that the grounds upon which the application is predicated are untrue. It is asserted that the defendant never filed a statement of defense until after the claimant filed his amended statement of facts, and therefore could not have responded to a statement of facts that had already been struck out. The claimant further contends that this present application is a ploy to delay proceedings. Upon a perusal of the processes filed in respect of this application, I am satisfied that counsel for the defendants inadvertently addressed the earlier statement of fact which had been struck out. Hence, there is a genuine need to amend the statement of defense to respond appropriately to the facts pleaded in the extant amended statement of facts. This position is also affirmed in paragraph 3C of the further affidavit in support of the application. To my mind, this constitutes a reasonable basis for amendments. It is settled law that amendments to pleadings are granted to ensure that the real issues in controversy between the parties are determined, and the overriding consideration of the courts is whether the amendment will further the cause of justice without occasioning injustice to the other party. In exercising its discretion, the court typically considers timeliness of the application, good faith, prejudice, necessity, and nature of amendment. See Eze versus Ene, 2017, 12 Nigeria Weekly Law Reports, part 1579, 313, 325 to 328. In the instant case, the proposed amendment seeks only to align the statement of defense with the extant amended statement of fact. It does not introduce a new course of action, nor does it cause incurable prejudice to the claimant. The error was inadvertent and on the part of defendant's counsel. Accordingly, this application succeeds. Nonetheless, I have observed that while the claimant filed amended statement of fact on 19 December 2024, the defendant did not file his statement of defense until 4th day of June 2025. Trial commenced on 6th day of November 2025, during which the claimant called 2 witnesses and closed his case on 22nd January 2026. Throughout this period, the defendant did not apply for leave to amend its pleading. This application for leave to amend was filed on 9th day of February 2026. In view of this delay, I find that the present application was not brought timeously. The grant of the amendment at this stage is likely to necessitate the filing of additional processes by the claimant and may require the recalling of witnesses, both of which would impose additional time and financial burden on the claimant. Accordingly, I am inclined to awarding costs as requested by learned counsel to claimant. The defendant is hereby ordered to pay costs in the sum of 50,000 naira to the claimant to compensate for the inconvenience occasioned by the delay. This cost shall be paid personally by counsel to defendant. The claimant is also at liberty to file such further processes as may be necessary in consequence of the amendments. Ruling is entered accordingly.
I'm most grateful, my noble lord.
You're welcome. So in view of this, I don't think we can.
My lord.
Yes, I don't think we can proceed with a continuation of hearing today. So we will have to give you another date.
Very well, my lord.
All right.
As the court places.
3rd of July.
Any dates?
Okay, 3rd of July.
3rd of July.
Yes.
It's convenient, my lord.
Yes, Baba Yemi.
My lord, 3rd of July is convenient, my lord.
All right, thank you. So upon agreement of both counsel, case is further adjourned to 3rd day of July 2026 for continuation of hearing. All right.
As
Thank
the
you,
court
counsel.
pleases.
Yeah, the court regrets the
Thank you,
delay
my
in
lord.
having this matter taken timely because we had the matter for Abuja, an ex parte application, so we couldn't get connected by 10. Yes.
Well, my lord, we're actually in court.
All right.
As
Okay,
court
that's good.
pleases.
Yeah.
Thank you,
my lord.
counsel. All right. So we may exit the platform now. Thank you.
Thank you, my lord.